A Paso Robles family is suing a local doctor after they say surgery on their loved one went fatally wrong. And sadly, they're not alone. A study by Johns Hopkins University shows more than 250,000 people in the U.S. die every year because of medical mistakes, making it the third leading cause of death. But because of a California statute that makes it hard to file a lawsuit against a doctor, just a handful are making their way through the local court system. One of those cases is Michael Picard's.
I lost my wife, my best friend.
Michael Picard's wife, Susan, went in for a partial hysterectomy in December of 2017. The 43-year-old mom of three died a little more than a month later.
Apparently she had a bad infection that wasn't caught and passed away in her sleep.
Picard's attorney, Nathaniel Leeds, says Susan's doctor found an infection and a clot the size of a grapefruit during a follow-up visit, and sent her home instead of to a hospital.
Had he done so, Susan would be here today. He did not.
Picard's case is just one of 7 Leeds' firm took last year, of the 4,000 that came through his office. And he only took it because Susan, who was a nurse, was the primary breadwinner.
If Susan Picard had just been a mother, the economics of the case wouldn't work.
And that's because of the Medical Injury Compensation Reform Act. It was enacted in California in 1975 to lower medical malpractice lawsuits. It caps non-economic damages or pain and suffering at $250,000. There is no cap to recover economic damages. So because Susan was employed, Michael has a case to recover her lost wages.
If a child is hurt, they have no wage loss. If an old person is hurt, they have no wage loss.
And he says no case, because Leeds argues the $250,000 cap often won't cover fees to litigate these costly cases. Supporters say the cap has worked to bring down lawsuits and bring doctors back to California.
There were more and more lawsuits. They were becoming more and more expensive to resolve.
San Luis Obispo-based attorney Mark Connolly has been representing physicians for the past 34 years. He says the high awards by juries made it nearly impossible for doctors to get insured, running them and insurers out of state. And now with efforts to repeal MICRA,
there's no necessary reason why it wouldn't return to the problem in 1975 if you go back to the circumstances that existed in 1970.
Michael Picard understands the debate.
I don't think society should be as sue happy as it is, but in my case, I don't have much choice.
The $250,000 cap is currently being appealed in Los Angeles. Other states have similar MICRA laws, but either adjust for inflation or the caps are set at higher amounts. And we should note Susan's doctor did not return our calls for comment.